Donald Trump has been criminally indicted for interfering with the 2020 presidential election. He's alleged to have participated in a vast conspiracy to interfere with the election and hold on to power. Yes, a federal grand jury impaneled in Washington, D.C. has indicted Donald J. Trump on 4 felony counts as part of Special Counsel Jack Smith's investigation into efforts to overturn the 2020 presidential election. As Jack Smith said in his press conference,
"Today, an indictment was unsealed, charging Donald J. Trump with felony violations of our national security laws, as well as participating in a conspiracy to obstruct justice."
So if you're counting, that makes 3 indictments and 78 criminal counts in 2 states and the District of Columbia. Donald Trump is the first president in U.S. history to try to interrupt the peaceful transfer of power to his successor, and the first Home Alone 2 actor to be indicted 3 separate times.
Down the hall and to the left.
So how close did the conspirators come to succeeding, and how serious did they think it would be for Trump to refuse to leave? Well, according to the indictment, when a deputy White House counsel told one of Trump's co-conspirators, Jeffrey Clark, that there would be mass protests if Trump remained president despite no findings of voter fraud, Clark said, quote, "That's why we have an Insurrection Act." Now, there was wild speculation about what this indictment would actually look like, and here what the Department of Justice did is very interesting. Instead of breaking things up piecemeal, they allege that all of the efforts to change or subvert the election are part of one general conspiracy that aimed to reverse the election. And while the indictment mentions the Capitol riots and Trump's speech from that day, none of the alleged crimes rely on the riots or that speech. The indictment doesn't charge Trump for inciting the January 6th riots. That would have been extremely hard to prove for reasons that we've discussed on this channel a lot, namely that the standard is very high and it would be very close to charging someone for potentially political speech. But here, the riots, according to the Department of Justice's narrative, were just another opportunity for the conspirators to delay or overturn the election. For example, during the riots, the conspirators were texting and calling senators to try to get them to delay certification and to pressure Mike Pence. So the riots were not an end in themselves, but a means to further the conspiracy. And this is a much cleaner way of conceptualizing the crimes, from the DOJ's perspective, than other ways that they could have drafted this indictment. Instead of lots of small towers with limited foundations, they constructed one giant tower with a huge base. Or more specifically, 3 large conspiracies sort of operating in parallel at the same time with generally the same aim. The first conspiracy was to overturn the legitimate results of the 2020 presidential election by using knowingly false claims of election fraud to prevent the actual slates of electors being collected, counted, and certified. The second conspiracy was to corruptly obstruct and impede an official proceeding, that is the actual certification of the electoral vote. And then the third conspiracy was to effectively hamper the right of some people to exercise their right to vote, effectively trying to discount or prevent the votes being counted in states where Biden won, where the conspirators were putting forth a fake slate of electors. Now, a quick word about conspiracy and free speech. Many are bemoaning the indictment as the criminalization of political speech, but that seems to be based on a misunderstanding of how criminal conspiracies actually work. Consider this great commentary from NYU law professor Noah Rosenblum. The First Amendment protects the right to free speech, but does that mean that you can say whatever you want without facing criminal liability? Not at all. Consider the following 2 scenarios. I walk into a store and buy a crowbar. No crime, life is good. 2, I call my buddy and say, let's go buy crowbars and use them to deprive people of their right to vote. He says, I agree, let's conspire to do this thing together. I walk into the store and buy a crowbar. Bad news, crime, life is bad. The only difference between these 2 acts is the fact of agreement, which is expressed in speech, although it needn't be. The crime is conspiracy, agreement to commit a crime plus a step towards its accomplishment. It's not the speech that's criminal, it's what the speech does, constitute an element of another crime. Here, Trump is charged with conspiracy, but the lies he made about the election are part of showing his knowing fraud an element of the crime. Don't worry, you can still lie in politics as much as you want, just don't do it as an element of another crime, like say participating in a conspiracy to defraud people of their right to vote. And that's exactly right. The only thing that I would add is a few other scenarios. The third scenario, a person says to themselves, I'm gonna go out and buy a crowbar to deprive people of the right to vote, and then I go out and buy a crowbar. Still not a crime because there's no conspiracy, i.e. an agreement with another person. Now that's important because in conspiracies, if you have an agreement, all you need is one overt act in furtherance of the conspiracy. And in the absence of a conspiracy, the act of buying a crowbar probably isn't enough to rise to the level of attempted interference. Because to attempt a crime by yourself usually requires conduct that constitutes a substantial step towards completing that crime. And then there's the fourth scenario. A person says to themselves, I'm gonna buy a crowbar to deprive people of the right to vote, buys the crowbar, and then actually starts hitting people waiting in line to vote. Now, still there's no conspiracy, but now you've taken a substantial step towards the crime and likely completed the crime, and you're guilty of that initial crime. So in the conspiracy context, and actually in many different legal contexts, speech will be relevant evidence. Was a conspiracy formed? What was the aim of that conspiracy? Did individual members have the requisite intent of the underlying crime? Was an overt action in furtherance of the conspiracy taken? Did the defendant say factually false things to induce others to act? But here, it's not the speech that's punished, it's the conspiracy. So with that in mind, that takes us to the indictment itself. The indictment starts by correctly noting that Trump had a right to speak about the election, quote, and even to claim falsely that there had been outcome determinative fraud during the election and that he had won. He was also entitled to challenge the results through lawful means, such as, quote, seeking recounts or audits of the popular vote in states or filing lawsuits challenging ballots and procedures. And as the indictment notes, Trump pursued these methods, but they were uniformly unsuccessful. However, Trump did not have a right to dispute the election through, quote, unlawful means of discounting legitimate votes and subverting the election results. The indictment says that Trump perpetrated 3 criminal conspiracies to stay in office. And we start with 18 U.S.C. 371. That section criminalizes the use of deceptive practices in connection with any conspiracy for the purpose of impairing, obstructing, or defeating the lawful function of any department of government. Trump is charged with conspiring to stop Congress from certifying the election by submitting fake electoral slates. And there are 2 prongs to Section 371 cases. The offense prong prohibits conspiracies to commit acts that are otherwise defined as criminal under federal law. And the defraud prong prohibits conspiracies to obstruct a lawful function of the government by deceitful means. And the government must prove that the defendant entered into a conspiracy with the specific intent to defraud the United States, that the conspirators used deceitful or dishonest means, and that one of the members of the conspiracy performed at least one overt act for the purpose of carrying out the conspiracy. For the government to prove that Trump committed the crime, it must show that he used deceit, craft, or trickery, or dishonest means to achieve it. Section 371 does not criminalize every conspiracy to disrupt a government function. It only reaches conspiracies that use deceit, craft, or trickery, or dishonest means. And we'll talk about Trump's defenses later, but he's probably going to claim that he didn't use deceit if he truly believed that he won the election. But the indictment concludes that Trump knew he lost, and the indictment lists all the people who told Trump that he lost, including the vice president, leaders of the DOJ who were appointed by Trump, the director of national intelligence, the director of the Department of Homeland Security's Cybersecurity and Infrastructure Security Agency, senior White House officials, campaign staffers, Republican state legislators and officials, and dozens of state and federal courts. And the indictment alleges that Trump privately acknowledged his loss. After the chairman of the Joint Chiefs of Staff urged Trump not to take action on a national security issue, Trump agreed, saying, quote, yeah, you're right, it's too late for us, we're going to give that to the next guy. Yet publicly, Trump repeatedly tweeted and encouraged his supporters to come to Washington on January 6th to stop the vote. And allegedly, in another conversation on January 1st, 2021, Mike Pence told Trump that he didn't think that there was a constitutional basis for Trump's claims that the vice president lacked the authority to change the results of the election. And quote, in response, the defendant told Vice President, you're too honest. Now, this strongly implies that Trump knew he had lost and was asking Pence to lie. And there are other examples. Apparently, he referred to some of Sidney Powell's theories as crazy. And even Rudy Giuliani said, quote, we don't have the evidence, but we have lots of theories. But despite this, it is alleged that Trump knowingly continued to make false claims about the election and further took actions to subvert the election. And the indictment notes that they might have tricked other people into action. For example, the fraudulent electors were, quote, tricked into participating based on the understanding that their votes would be used only if the defendant succeeded in outcome determinative lawsuits within their state, which the defendant never did. The defendant and co-conspirators then caused these fraudulent electors to transmit their false certificates to the vice president and other government officials to be counted at the certification proceedings on January 6, 2020. Now, some legal commentators claim that the government needs to prove that the defendant intended to swindle money or other tangible objects from the victim in order to be charged under Section 371. But that's only true if Trump was charged with a fraud crime like wire fraud. But here, he wasn't. The prosecutor doesn't need to prove that the conspiracy actually led to any property or monetary loss by the US government or its agencies. The Department of Justice's Criminal Resource Manual cites a 1924 case, Hammerschmidt versus United States, for this proposition. And in that case, Justice Taft wrote, quote, it is not necessary that the government shall be subjected to property or pecuniary loss by the fraud, but only that its legitimate official action and purpose shall be defeated by misrepresentation, chicane, or overreaching of those charged with carrying out the governmental intention. And several more recent cases have affirmed that the word defraud in Section 371, quote, not only reaches financial or property loss through the use of a scheme or artifice to defraud, but also is designed and intended to protect the integrity of the United States and its agencies, programs, and policies. Now, the second criminal charge relates to subsection 1512K, which makes conspiracy to violate Section 1512 a separate offense subject to the same penalties as the underlying offense. And a 1512K charge has no specific overt act element, and the courts have generally declined to imply one under such circumstances. Now, regardless of which section is invoked, conspirators are criminally liable for any crime committed in the foreseeable furtherance of the conspiracy. The indictment says that Trump, quote, did knowingly combine, conspire, confederate, and agree with co-conspirators, known and unknown to the grand jury, to corruptly obstruct and impede an official proceeding, that is, the certification of the electoral vote. Now, there are many examples of Trump and his co-conspirators trying to stop the certification process, and their actions on January 6th are notable, as the indictment accuses the conspirators of exploiting the violence at the Capitol in furtherance of their plot. After the rioters had been removed from the Capitol, Trump, through White House aides, attempted to reach 2 United States senators at 6 p.m. From 6:59 p.m. until 7:18 p.m., Rudy Giuliani placed calls to 5 United States senators and 1 United States representative. Co-conspirator 6 attempted to confirm phone numbers for 6 United States senators whom defendant had directed Giuliani to call, an attempt to enlist in further delaying the certification. Quote, in one of the calls, Giuliani left a voicemail intended for a United States senator that said, quote, "We need you, our Republican friends, to try to just slow it down so we can get these legislatures to get more information to you and know they're reconvening at 8 tonight, but the only strategy we can follow is to object to numerous states and raise issues so that we get ourselves into tomorrow, ideally until the end of tomorrow." Trump also called another senator, repeating false allegations of fraud in Arizona and Georgia. He also, quote, claimed that the vice president's actions had been surprising and asked the senator to, quote, object to every state and kind of spread this out a little bit like a filibuster. Shortly before the meeting to certify the election, White House counsel urged Trump to drop his objections and allow the meetings to proceed. Trump refused. The meeting of Congress was delayed for 6 hours, and when it resumed at 8 p.m., it certified Biden's election as president. Now, it's actually not weird that Trump's co-conspirators were lawyers, because sadly, finding a great lawyer is hard to do. But if you need a really good lawyer, my firm, Eagle Team, can help. If you've been in a car crash, suffered a data breach, or have a Social Security disability issue, we can represent you or help find you the right attorney who can. Just click on the link that's in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. And the link is down below. And the third charge relates to 18 U.S.C. 1512c2. Trump was indicted for obstructing an official proceeding of Congress. Now, the initial media reports about the target letter were confusing because they reported that Trump was being charged with witness tampering. And that's because the short title of 18 U.S.C. 1512 is tampering with a witness, victim, or informant. But here, Trump wasn't charged with witness tampering per se. Section 1512 covers other kinds of obstruction of justice. He was actually charged with violating Section C2 of the statute, which states, whoever corruptly obstructs, influences, or impedes any official proceeding or attempts to do so shall be fined under this title or imprisoned not more than 20 years or both. Now, Section 1512c was added to the code as part of the Sarbanes-Oxley Act of 2002. And to convict Trump under this statute, the government has to prove that he attempted to obstruct an official proceeding and that he acted with corrupt intent. The first element is relatively simple for the government to prove. Many of the January 6 rioters were charged with violating 1512c. These defendants argued that the January 6 meeting of Congress was not an official proceeding, but courts ruled against them because Section 1515a1 defines official proceeding for purposes of Section 1512 to include a congressional proceeding. Now, the second element is whether Trump acted with corrupt intent. And some of the January 6 defendants challenged their indictments on the grounds that this element is unconstitutionally vague since the word corruptly isn't defined by Section 1512c. But several circuit courts have already rejected this contention. The courts conclude that corruptly in 1512c includes 2 components: 1, intent to obstruct, impede, or influence, and 2, wrongfulness. And then count number 4 relates to the deprivation of rights under color of state law under 18 U.S.C. 241. Now, under that section, a government official can't deprive someone of their rights. And the statute dates from the Reconstruction era, but it doesn't require that the defendant's conduct be motivated by a specific bias against the victim, such as race, gender, or discrimination. But Section 241 makes it unlawful for 2 or more persons to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same. And here the idea is that the conspirators conspired to prevent people from being able to exercise their right to vote. The offense is always a felony, even if the underlying conduct would not on its own establish a felony violation of another criminal civil rights statute. Now, critics of this indictment believe that Trump shouldn't have been charged with violating Section 241 because this law was passed during Reconstruction as a way to punish members of the Ku Klux Klan and other people from harassing black voters. And while it's true that this law was originally aimed at stopping harassment of black voters after the Civil War, it is in no way limited to stopping white Confederates from intimidation and harassment. And the DOJ has used this law to prosecute conspiracies to prevent the proper counting of ballots in federal elections for more than 100 years. The DOJ has charged government officials under 241 when officials tried to stuff a ballot box with forged ballots, prevent the official count of ballots in primary elections, destroy voter registration applications, destroy ballots, exploit the infirmities of elderly or handicapped people by casting absentee ballots in their names, illegally register votes and cast absentee ballots in their names, injure, threaten, or intimidate a voter in the exercise of their right to vote, impersonate qualified voters, fail to count votes and to alter votes counted, to steal votes by changing the votes cast by voters in voting machines, and the list goes on and on. Now, many of these alleged crimes will hinge on Trump's mental state. And we've covered this before. Did Trump have a specific intent to obstruct, impede, or influence the proceeding of Congress? Well, it's definitely possible. But since this indictment came down, there have been a lot of bad legal takes about what it actually means, especially with respect to Trump's mental state and what the prosecutors actually have to prove. Many journalists and even some lawyers have said that in order to convict Trump on these charges, prosecutors must prove that Trump knew that he lost the election. See, for example, this headline in the Washington Post, which says, "The former president's intent and whether he knew he was lying about the election fraud are key issues for prosecutors." Now, this is a big misunderstanding about what prosecutors must prove about Trump's mental state. Now, look, this stuff is hard, but it's not that hard. Now, first of all, criminal prosecutors prove intent and internal mental states all the time. It's not impossible. It's not even that hard. You can do it using statements that the defendant said. You can prove it using surrounding circumstances. Or in the case of conspiracies, you can even use the statements of your co-conspirators. Because in a conspiracy, you're generally liable for the acts of your co-conspirators, and the statements of your co-conspirators are not hearsay. And second of all, prosecutors have been using the statutes under which Trump has been charged against the January 6th protesters with great success. And Trump's potential defenses and issues about mental states have been raised and repeatedly rejected. He's not the first guy to claim that there was election fraud and thus his actions were excused. Now, to review, the DOJ says that Trump intentionally participated in 3 conspiracies that violate federal law. First, Trump is charged with violating Section 371 that makes it illegal to conspire to defraud or lie to the United States. The meaning of defraud is interfering or obstructing a lawful government function by deceit, craft, or trickery or dishonest means. The indictment alleges facts showing that Trump used deceit and trickery and dishonest means to replace the legitimate electors with fake ones. And that's the reason for the heading on page 27, which says, quote, "The defendant's attempt to leverage the Justice Department to use deceit to get state officials to replace legitimate electors and electoral votes with defendants." And what Trump believed about the 2020 election, and thus whether he lied or was mistaken, goes to the element of deceit in Section 371. And that's arguably one of the reasons why the indictment contains so much information about whether Trump lied or not. In addition, it also just provides color and explanation about his motive. And if he did not actually believe he won the 2020 election, he would almost certainly have violated Section 371's prohibition against defrauding the United States government, i.e. lying to the government. But the second conspiracy is that Trump and his co-conspirators obstructed the January 6th congressional proceeding where the election would be certified in violation of 2 sections of Section 1512. And someone else who was charged with this violation is January 6th defendant Alan Hostetter, who was charged with violating Section 1752C2 and 1512K, just like Trump was. He tried to raise the First Amendment defense that Trump will rely on, but a federal judge rejected this defense, explaining that, quote, "Mr. Hostetter is not being prosecuted for engaging in protected First Amendment activity, and I am making my decision without regard to his political beliefs, which I believe he holds sincerely. Mr. Hostetter has a right to believe whatever he likes about the 2020 presidential election and to voice those opinions. But the First Amendment does not give anyone a right to obstruct or impede Congress by making it impossible for them to do their jobs safely." The judge ruled that Hostetter and his co-conspirator, quote, "knowingly and intentionally entered into that agreement with the intent of furthering its unlawful goal of disrupting and impeding the Electoral College certification." And similarly, in Trump's situation, the government need only show that he intentionally took steps to obstruct the Electoral College certification. So for example, when the government points to Trump's speech at the Ellipse, they don't have to prove that in his mind, he knew everything he was saying was a lie. Instead, the speech is evidence that he wanted to encourage people to physically occupy the Capitol. And once those people were inside the Capitol and the certification was delayed, Trump and his co-conspirators continued to act in furtherance of their conspiracy by calling senators to further delay the vote. And Trump's subjective belief and motive might help explain those actions, but they're not necessary to prove the crime that he's alleged of. And the third conspiracy is that Trump allegedly interfered with the right to vote and to have one's vote counted in violation of Section 241. And that section requires that the defendant had an intent to deprive an individual of their rights and that the federal right violated was clearly delineated. And in a January 6th prosecution of Douglas Mackey, a jury instruction explained that the government had to prove, quote, that the defendant knowingly and intentionally joined the conspiracy with the intent to further a specific objective. And the Mackey jury instruction explains how a jury should assess the defendant's criminal intent within the context of this particular section. Quote, "The indictment alleges that the objective of the charged conspiracy was to injure, oppress, threaten, or intimidate one or more persons in the free exercise and enjoyment of their right to vote. The government must therefore prove beyond a reasonable doubt that the defendant knowingly and intentionally joined the conspiracy with the intent to further that objective. In this case, the government has alleged that the object of the conspiracy was specifically to injure one or more persons in the free exercise and enjoyment of their right to vote. I instruct you that the statute covers conduct intended to obstruct, hinder, prevent, frustrate, make difficult or impossible, or indirectly rather than directly assault free exercise of the right. For example, hinder is defined as to make slow or difficult the progress of, to hamper, to hold back, to prevent, to check." And again, Trump's subjective belief about the overall election or election fraud isn't necessary or an element of the crime. So with the possible exception of the first count, Trump's subjective belief about the 2020 election is basically irrelevant. It's his intentionality about his actions that matter. Here's how elections lawyer Mark Elias explained it. Quote, "I walk into a bank and I think they're wrongfully holding my money. I think my balance is $5,000 and they think my balance is $0. And I genuinely believe that I'm owed $5,000. That doesn't excuse me from robbing the bank. I can't pull out a gun and take the money. Particularly with the fake elector scheme, even if you believe that you won, you were not entitled to have people submit fake forms on January 6th. Now, the rioters unsuccessfully took down the US Capitol, but you can successfully get your online data taken down with today's sponsor, Incogni. Now, I don't know about you, but I've seen a huge uptick in the amount of spam that I'm getting, and it's no surprise why. Every year, the number and scope of data breaches worldwide is rising, and you might not know it, but there are hundreds of data brokers that possess and sell your personal information, and their numbers grow every year. These data brokers might have a whole shadow profile on you, including your name, your address, phone number, shopping habits, possibly even your social security number, all up for the highest bidder. At best, this leads to scam calls, and at worst, identity theft and doxing. But that's where Incogni comes in. Incogni fights on your behalf to remove your personal data from data brokers and deals with any objections from their side. All you have to do is create an account and give them approval to work on your behalf. Incogni conducts repeated ongoing removals because even if the data broker removes your data once, they can collect it again, which is just incredibly dumb. But Incogni makes sure that your personal information stays off the market for good. And you can actually see when Incogni does this on your personal dashboard. This is my personal dashboard that I paid for. It shows that these 3 sites had data on me that was rated 10 out of 10 on Incogni's sensitivity scale. These brokers had data including my contacts, financial data, and health data. Thankfully, Incogni tells me when the removal requests are complete so I can breathe easy. Now, it's terrifying to see exactly how many brokers have my data, but it's really fun to watch Incogni get them to delete that info one by one. So if you'd like to give Incogni a try, click on the link below to get 60% off Incogni when you use the code LegalEagle. So to get an exclusive 60% off, just click on the link that's on screen right now or down in the description and use code LegalEagle. After that, click on this box over here for more LegalEagle, or I'll see you in court.